So I'm Gary Burger of Burger Law. We're going to have a great seminar today. We're very excited. We're going to do it in three parts. We're going to do it in, I'm going to talk to you about the basics of handling a small personal injury case. We're going to talk about 20 advanced trial tips, which is now 31 with my mom, Joanne Burger, because we both wrote, I wrote 13, she wrote 18. We're kind of put it together. And then I'm going to do an ethics presentation, which I think are the top 10 ethics issues. It's the most ways that people get complained of, and it's the most frequently encountered in litigation. So without further ado, and I'm going to just keep going, and if you guys have questions for me as we go, please raise your hand. This is for you, not for me. My goal in these, and I've done a bunch of them, is not to tell war stories, but to give you kind of things that you can do and you can take from here. All your materials are in front of you. Everything I'm going to say is in there, but I'm going to add stuff to it too. So depending on what kind of practice you have, small personal injury cases can be a very good use of your time. Some people are a little loath to take them because they don't know quite what they're doing if they have a general practice. Some people do them all the time. But they're really, if you can get the basics down and know what you're doing, they can be very profitable. They can enable you to fully serve your clients, and I'm going to get right to it. So there's three basic areas. There's car crashes, there's slip and falls, and there's work comp. I'm not going to talk about work comp. So let's talk a little bit about vehicle accident law, and if you've had these cases. So to recover against a defendant for negligence, they have to be negligence. You have to show that the plaintiff was a motorized vehicle being operated on a roadway and approximately caused damages. So, and when you talk about approximately caused damages, obviously all these are obvious things, but they're really, if you handle a lot of these cases, you have very varied situations in there. So all of the law and all of the jury instructions are basically MAI 17.01. But if you're ever instructing, you want to also use 1901, because what that does, it expands the proximate cause issue from just proximate cause from just directly caused to directly caused or directly contributed to cause an injury to someone. So always use 1901 when you're doing that. And that's because if you have a client with a degenerative back condition, but they're later injured by this case, the car accident only has to contribute to cause those damages. Similarly, if you have multiple wrecks, or multiple vehicles involved in the wreck, that's also where this goes to. There's a great Supreme Court case in the comments to use, the notes on use in MAI, which is where if you instantly want to get the best law in any of these areas, go to the notes of use in MAI and any of the substantive sections that you need to reference. And that'll get you right there. So that's generally, in terms of the standard of care and the burden of proof, what you need. I would like to remind everybody, and we could wait for some more people to hear, but basically remember that this is for free, and that we ask that you give Legal Services a generous donation to pay for the CLE today. I have envelopes in each of your packets so that you can do that. And while we're in here, you're all going to hopefully get an email from me with a direct link to how to contribute to LSEM online if you didn't bring your checkbook with you. So we do ask that you support Legal Services. Dan Glazer, the CEO of Legal Services, was here for the morning session. We sold out our morning session, which is for free. You wonder how that happened, right? So we're going to do the afternoon session too, and we're happy that you're here. So use 1901. It's a lesser standard. I just was arguing 2 weeks ago. I got the judge in a long case to use contributed to cause, and it's the right standard in almost all cases. So insist on that. So most of your cases, you think you're going to be on a public highway, but there's a difference between the standard of care for a public versus a private roadway. If it's a public roadway, a driver has to exercise the highest degree of care. And if you look at MAI 1102, that's going to define your standards of care. So on a public roadway, it's the highest degree of care, and the definition of care of negligence is that the driver must be act as a very careful person would do under same or similar circumstances. However, if it's a private road, someone only has to act ordinarily careful. And you'd think that wouldn't happen, but parking lots are private. They're not public thoroughfares. So if you have a parking lot case, that's going to be a private roadway or a rural roadway. And many times adjusters are going to throw that at you. Well, it's a private, it's only ordinary care, blah, blah, blah. Feel free to climb on in and grab a seat anywhere, no worries, and welcome. So they're going to throw that at you, but frankly it ends up being somewhat of a distinction without a difference, because if you go talk to the person and you're deposing them, I mean, would an ordinarily careful person rear-end my client or blow a stoplight or blow through a stop sign or something like that? So there you go. Think about that when you're doing that. And I'm going to reference, there's a lot of cases cited in here. There's a lot of references to MAI, which is the shorthand version of getting to the standards and the burden of proof and what you ultimately need to prove at trial.